Hello viewers, welcome to Ekam Academy. Today, as part of the concept of the day series, we'll be discussing about two important concepts related to judiciary, that is judicial review, judicial activism and judicial overreach. So we'll also discuss the concept of judicial restraint. As some of you have asked in the comment section, today I'm discussing these topics in detail. So let's first understand what's the brief thing we have to understand regarding judicial review. Right? So first let us understand what is the meaning of the term judicial review. Right? So according to the constitution, we know there is a clear devolution of powers among three organs of the government. So the main job of the judiciary is to interpret the constitution. That means they also have to check whether any act made by Parliament of India or any decision taken by executive is in accordance with the constitution or not. If they found that is in violation of the constitutional provisions, then that has to be declared null and void. So this power is what conferred to the judiciary by the Constitution of India, and that will be called as judicial review. And this can be exercised using many articles like Article 13, Article 32 and 226, right? So this is what you have to keep in mind with respect to judicial review. That means whether there is authority to pass that particular law or to take the decision or not. That is the first thing. And is there any violation of fundamental rights? Or third thing, is it in violation of any constitutional provisions or not? So these things will be checked as part of judicial review, right? So this concept we have borrowed from US Constitution, right? Then next concept we have is judicial activism, right? So judicial activism. So what is the meaning of the judicial activism? That means here judiciary will be playing a more proactive role in interpreting the things or in framing or formulating of different things. For example, if it feels that legislature and executive are not doing their job, then if it is becoming more active and like advocating that you have to do this and all, then we can call it as judicial activism, right? So judicial activism is you can understand through the concept of public interest litigation, right? So we know this is having its origins in USA, and India it was brought by Justice Krishna Iyer, P.N. Bhagavati, right? Chinnappa Reddy, D.A. Desai, like that. We have many important judges who have originated the concept of PIL in India. That is the best example of judicial activism, right? So when there is a, you can say a violation of fundamental rights, if the Supreme Court feels so, or if there is no proper effort taken from the legislature or judicial executive side, so then also they can become more active. So the opposite concept to judicial activism is judicial restraint, right? So judicial restraint. So it is clear opposite to judicial activism. That means judiciary, when it was knocked at the door, like you want, please issue some order, or you please consider this particular thing. So then when they feel that it is not the job of judiciary to interpret, then they may simply avoid that particular interpretation by restraining themselves. That is what we call it as judicial restraint. So the best example of judicial restraint you can say in the case of S.R. Bommai versus Union of India case. Although Supreme Court has interpreted the constitutional issues related to that particular case, in political aspects of that particular case, it said clearly it's not the job of the judiciary. So this is one example you can write in the judicial restraint. Then we talk about judicial activism. What are all the cases related to this? We can write the case of Keshwananda Bharati case, right? So, and where they have given basic structure doctrine, right, by taking the proactive role or the leading role. At the same time, you can also write Golaknath case. At the same time, we can also cite the example of Vishaka guidelines, right? So, you know, Vishaka guidelines were passed by Supreme Court with respect to protection of women from sexual harassment at workplace in 1997. So this is also said to be a proactive role played by the judiciary in interpreting the constitution values. So then next topic we have is judicial overreach. So what is the difference between activism and overreach? So you can also call judicial overreach as judicial adventurism. Adventurism or overreach are same. That means here, compared to judicial activism, which is more proactive, it will step into the shoes of legislature and executive. So it is not just activating itself, or it is not giving some commands and directives to the legislature and executive. It will step directly into the shoes of legislature and executive, and it will by itself pass the orders. For example, imposing firecracker ban in Delhi. So we know because of pollution, although the intent behind judiciary and its decision is correct, right? But it is not the job of the judiciary to impose a blanket ban on celebration of Diwali through firecrackers in Delhi. That the intent was not actually checked, because if you generally step into the shoes of another organ, it's a clear violation of separation of powers, which was mandated by the Constitution of India, right? So that is one main thing. Along with this, we also have national highway liquor ban, right? So along the national highways for 500 meters you cannot have any liquor shops. So to prevent accidents and all these things, the intent is also good again, but still it was not the domain of judiciary to interpret and to act in this regard. So these are the various cases and instances of understanding the concepts of judicial review, judicial overreach, judicial restraint, which is opposite of judicial activism, right? So I hope the concepts are clear. Now let us see the practice question. So which of the following best describes the judicial activism? So 4 options were given. Try to choose the correct one and let me know in the comment section. So today we have discussed about the concepts of judicial review, judicial activism, judicial overreach, at the same time judicial restraint. So we have discussed what is the basic concept of these things along with certain examples. So if you found the video useful, let me know in the comment section. Thanks for joining. All the very best.